And then the area that comes up probably most often, second to the replevin cases I hear a lot about, is what if my dog bites someone? And this is usually seen from the plaintiff's perspective of someone suing over a dog bite. But from the perspective of the dog owner, this is looked at a little bit differently. Here, know that a dog owner can face criminal ordinance, which is quasi-criminal, and civil liabilities. Animal attacks are addressed in state and local laws. In Illinois, the state law was enacted to circumvent a common law requirement that a dog owner know about his or her dog's vicious or dangerous propensities before the dog owner could be held liable. And that was what's commonly known as the one bite rule, or one free bite rule, which in Illinois really doesn't exist because the statute got rid of it. It can exist under common law to the extent that if a person truly did not know that their animal had these propensities, then they are not going to be held liable necessarily for the first bite under the common law principles of civil law. But the Illinois statute, which is also, I know, have been adopted in many states, will take away that one bite rule and make the person liable, with the exception of situations of provocation. Oh, I apologize. We have another question that came in. It says it's more related to the veterinary malpractice, but it says here, after an owner files a malpractice claim against a vet, what impact does that have in the veterinary community regarding their willingness to treat other animals owned by the plaintiff? Interesting question. That I don't know. To the extent that most people have filed a malpractice claim, I know that the plaintiff, probably would just take their animal, obviously, to a different place, or I should say, sometimes during the course of a veterinary malpractice case, to bring their animal back to health if the animal has not been killed. They will already be working with another vet to bring that animal back to health. So it's usually not an issue. And there are veterinarians that, don't hold the views that were ascribed by the earlier person, which I noted from Orchard Road, who said all animals are property. I don't tell my clients this because I don't think they'll understand. But there are other veterinarians who don't believe that and do believe that veterinarians should be subjected to the higher standard. Because it does raise the status of not just the animals, but also the veterinarians who care for them. They are the other family doctor. But I don't know that many have had problems taking their animals to another vet. Because just like in any community, like the legal community of attorneys, we know that most of the attorneys are going to be very good and they're going to be careful and they're going to do everything they can to practice well, but if they make an error or mistake, then they pay for that. Same thing with the veterinary community. If an error or mistake was made, most of the time a case will settle. But if it doesn't and it goes through trial and becomes very public, then yeah, there could be some backlash, but I have not yet seen it because I've not had any clients report that they've been unable to get treatment. I will note, though, for obtaining expert review of files, because, and this is just an observation, it may be different in other areas, but in my area, the veterinary community tended to be somewhat more close-knit, and it's very difficult to find a veterinarian to find fault with another veterinarian's work in that local community, because no one really wants to testify against another. Vets tend not to want to testify against other vets. Different from the medical profession, where it is somewhat easier to find an expert to testify against another medical doctor, the veterinary community is still somewhat smaller. But it is still possible to have these records reviewed. You may need to go out of state. You may need to go to a teaching hospital. You may need to go somewhere where you can have a neutral look at these records and tell you if you have a breach of the standard of care or not. But as far as willingness to treat other animals owned by the plaintiff, obviously they're not going back to that same vet. They're going to a different vet. And I've yet to see that, but it is an interesting concern and does tie in with the veterinary community's argument that they are concerned about increased damages and that would increase the cost of vet services to everyone and also increase their costs of malpractice insurance. So it is a concern. I'll have to ask about it to see if anyone's had problems, but none have been reported to me just yet. If that didn't fully answer, please send in another question. But as far as the dog bites and how a dog owner faces some potential liability, This can arise in the three situations we noted. The criminal situation is very rare, but it is possible. If a dog owner were to somehow mistreat their dog badly enough that their dog reacted harshly, very harshly, to someone who had done nothing wrong. And I do know of a situation that criminal charges were filed against someone for more of a negligent homicide because the person was killed by their dog as a direct result of their mistreatment of the dog, or as alleged anyway. Also, in ordinance violations, this comes up when an injury occurs. Now, that can be an injury to a person or to another companion animal, and the penalties will vary based on whether it's brought under a state law. States have administrative hearings, but also under a municipal law. These penalties can range from, euthanasia, which is the most extreme, to banishment, or things like muzzling, fencing, getting insurance, licensing, and additional training. And also on the civil side, because regardless of what happens in the criminal or quasi-criminal ordinance violation situation, the dog owner is likely to be sued in civil court for damages, for personal injury. And that does include, and can include, damages for another dog that's being attacked by the animal, or usually any other companion animal, cat, dog, rabbit, whatever else, whatever other animal may be owned by another. Now, while most of the statutes and ordinances do not impose strict liability as a pure penalty for dog ownership, and defenses do exist, many of the ordinances impose civil liabilities and seek restitution for injuries to persons and companion animals, or for the persons and their companion animals that were attacked. Now, know that this is very important. The ordinance language will vary and is going to be governed first on your local level and also referencing the state level, because here, an animal can be considered dangerous if they simply threaten an attack or an apparent attitude of attack in some places. Other places will require actual physical contact. So the language that defines dangerous or vicious does vary and will depend on whether or not some type of physical injury is required or if a dog simply looks mean, which is very strange, but it does occur. Other municipalities require the actual puncture wound or multiple aggressive acts to qualify a dog as dangerous. But most municipalities do have laws in place that deem dogs attacking other companion animals. So not just persons. It's not, people sometimes are surprised when they find out that their dog may have attacked another dog and they're being sued or they're being brought into an ordinance violation court for their animal's actions towards another animal. But that is typically covered in these statutes. So definitely take a look at them and look very closely at what is covered and what is not. And also, whether an animal would be deemed dangerous or vicious would depend on the severity of the injury. And know that a dog is unlikely to be named dangerous if the dog was responding to pain, if the dog was defending a person, or if the dog was provoked, or I should say person or their offspring, the dog's own offspring, or the dog was provoked or the act justified somehow. So it's not as clear as some, as it potentially, I guess, as some people may think. But when a dog bites, there are a number of factors to look at, and one of those is, in fact, the severity of the injury and whether or not provocation exists. And the provocation defense will vary, and it can be defined specifically in the municipality, but generally it's responding to pain, defending a person, defending offspring, or otherwise justified. Now, it may be a caveat sort of Illinois law, but for some reason we just have a lot of cases that talk about the reasonable dog standard. And yeah, the first time I had to say that in court, I remember the judge looking at me saying, "Reasonable dog standard? Are you making this up, counsel?" And, no, I wasn't. I actually had to hand him the cases on this, and he read them aloud in court. But was at the end, kind of surprised, but intrigued that, yeah, the reasonable dog standard does exist The Illinois courts have a very good explanation of it, and I put that in the resource list as far as cases to reference and look at, because it is pretty interesting. Here, a reasonable dog is considered when determining whether a dog was provoked. Some courts will consider this standard, which is how an average dog, neither unusually aggressive nor unusually docile, would react to an alleged act of provocation. And know that in a lot of cases and in a lot of ordinances, provocation need not be intentional. It can be any act, even if it's an accident. Stepping on the dog's tail, whether you meant to or not, can provoke a dog. It need not be committed by an adult. So a toddler whacking the side of a dog, can, in fact, be an act of provocation. Provocation can include an evaluation of whether the person encountering a dog assumed the risk. So if a dog is guarding, like your traditional guard dog, is in front of a house, chained, growling at someone, and you approach that dog, you may well have assumed the risk, and therefore allowed the act of provocation to be a defense to those dogs' actions. There, especially if the dog is exhibiting aggressive tendencies at the time of the encounter. So if you see a hurt or injured dog and you approach the dog and are bit by, and if your client is bitten by the dog, you're going to be less likely to recover from that dog owner because that animal is responding to pain and was provoked, whether or not the person who approached the dog intended to provoke the dog. It's viewed through the eyes of the dog, or a reasonable dog. Now, that doesn't mean that a dog can lash out or behave as a dog, not as in a manner different than a normal dog. So a dog responding to another dog barking by mauling that dog to death is not going to be considered provoked. Because that's not a normal response to another dog barking. But if a child pulling food out of a dog's mouth, if the child is bit, that is considered an act of provocation under many of the cases. So it is important to look at this factually and consider what provocation would be. And you can reference the Illinois cases. If your own state doesn't have them, you can certainly reference them and make the arguments for a standard similar, because that is what a lot of the experts have established is how a dog's reaction should be gauged, what a reasonable dog would do in a similar situation. Now, as far as the trends, in ordinance violations, a big hurdle has been the permanent status of a dangerous dog. Because here, if a dog is deemed dangerous, and if they're not euthanized, as can happen, especially under the City of Chicago rules, it's been happening a lot lately, if a dog escapes euthanasia, or it isn't banished, but is subjected to a number of penalties, such as, enclosure in a yard, high fences, many different licensing requirements, always having a muzzle on when walked, all of these things, it can severely impact the quality of that dog's life. It can also result in an owner or caretaker being unable can result in a caretaker being unable to house the dog for the insurance requirements. Now, there's also removal of the dangerous designation may be appropriate after a sufficient period of time and training, along with the passage of certain tests. So this has been kind of a newer trend in what's being allowed as far as dog owners and dog ownership. Now, I wanted to address a question. Someone had posted, and I'll put this in materials for later, and I apologize. There's some cases from 1914 someone had posted in Oklahoma, a Supreme Court case, where a jury had given someone $150 for the death of a cat killed by neighbors. I thought that is an interesting case. Granted, it's 1914, but it's certainly worth noting, and I appreciate someone sending that in. It was Hensel versus Fletcher. So as another source for valuation, it's for habits and propensities of the animal evidence can add or detract to the value of the animal. So that is another point that certainly could be considered. And it is 225p 514 1914 Oklahoma. So thank you for submitting that. And if anyone else has some cases they'd like to submit, please feel free. I was not familiar with the Helsel case, but I will add it to the list. So very interesting stuff. But as far as particular dogs in a dangerousness situation or a vicious dog designation, some of the courts or some of the legislatures, whether it be municipal or whether it be state, have been looking at removal or possible removal of the dangerous status because it comes up more often when there's a second instance. And if, obviously that's something you want to avoid, but if there was an accident, someone even just forgot to have the dog's muzzle on one day, if that dog, at least in the Chicago laws, if they're seen out without the muzzle, if they get out of the house and just run, if they encounter any other animal without subscribing to the prescriptions that were placed upon them under the dangerous dog ordinance, that dog could, under the executive director's discretion, be euthanized, even if the dog had not really committed a harm. So that's why people have been hoping to get, or at least a lot of dog owners have been hoping to see if there's a way to rehabilitate their dogs where that dangerousness status could be removed. So that is something it's happened in one county in particular where we were successful in removing the dangerousness status. But it's not been widely accepted yet, but it is of interest, and it has been coming up more and more as an option and something that could save a lot of animals from unfortunate designations for the rest of their lives. But it's also, another trend is a reckless owner. So this makes the focus more on the owner of the animal as opposed to the animal itself. Because, and this is more aimed at bad owners or owners whose dogs have developed bad behaviors as a result of negligence or the failure to provide proper care. So such as a dog that's chained out in the front of a yard for its whole life. And there, if a dog were to bite someone, the animal owner in that situation may be simply willing to have their dog euthanized and just go get another dog, rather than have this repeat in a cycle over and over again. Some of the focuses of these laws have gone more towards the owner, maybe increasing fines, penalties, fees, and putting a bar on ownership for a certain period of time of an animal in an effort to prevent that cycle from continuing.